Section 18C should in some way, operates in some way to make certain subjects taboo is just, again, a mischaracterisation of the way the law works. And the whole reason we're having this debate nationally is really because of one case out of all the cases that have been decided under this legislation, and that was the Andrew Bolt case. And if you actually read what the judge wrote in his judgment, I just want to quote this paragraph because it makes the point that there is no subject which is taboo. It's the way you address the subject that counts. And he said, nothing in the orders I make should suggest that it is unlawful for a publication to deal with racial identification, including by challenging the genuineness of the identification of a group of people. I have not found Mr. Bolt and the Herald and Weekly Times to have contravened Section 18C simply because the newspaper articles dealt with the subject matter of that kind. I have found a contravention of the Racial Discrimination Act because of the manner in which that subject matter was dealt with. And then he went on to outline what it was about the manner in which that subject matter had been dealt with that had led to a finding of contravention. And it was really three things: a combination of factual errors, distortion of the truth, and racially inflammatory language. Any one of those three things, possibly by themselves, would not have been sufficient to lead to a finding of contravention, but the combination of those three things did. And I was just having a quick look through some of my notes this afternoon, and to back up the truth of that conclusion in that judgment, there was a much earlier case which was decided by the Human Rights and Equal Opportunity Commission, the predecessor body of the Australian Human Rights Commission. It was a case of Walsh versus Hanson. That Hanson. And it was about a book written by Pauline Hanson and David Ettridge, which suggested that the Aboriginal community was being favoured by government, and you know, we're all familiar with the sort of line that was being pushed at that time. But what was interesting was that in that case, the complaint was dismissed because the subject matter itself wasn't sufficient to lead to a finding of contravention. It was the fact that even though scholarship may have been bad scholarship, it was bona fide scholarship. You don't have to have good scholarship to constitute something that's done reasonably in good faith. You can have very bad scholarship, it can be riddled with errors. People are allowed to make mistakes. But when you combine it with the other factors that were found to have been present in the Andrew Bolt case, then you do get a finding of contravention. And I think the Walsh and Hanson case is actually a standing testimony to that. The only other thing I wanted to say, and it's not quite an answer to the question, but it's an important point. This dichotomy that's drawn between free speech on the one hand and freedom from vilification on the other, I think in many ways is a completely bogus dichotomy. And I think Liz sort of alluded to that earlier, and Tim too. One of the most pernicious harms of racial vilification is its silencing effect on the target group or individual. So if anything really silences free speech, freedom of expression, it's when at the other end of racial vilification. And of course, because of what I've just said about the Bolt judgment, the law itself doesn't really impose any constraints on what you can talk about. One of the ironies of all of this is that if you abolish Part 2A of the Racial Discrimination Act, and that's not just 18C, but all the cognate sections B, C, D, E, F, and so on, you get rid of Section 18D. Section 18D is the list of exemptions and defences to a complaint under Section 18C. Section 18D is one of the very few legislative codifications of freedom of speech that we have in this country. As was pointed out in the introduction, we don't have a Bill of Rights. We don't have a constitutional protection of freedom of expression. We do have Section 18D of the Racial Discrimination Act, which the free speech absolutists want to get rid of. So I'm finding it a rather surreal debate in many ways, and the dichotomy that's been drawn between freedom of expression on the one hand and freedom from racial vilification is in many ways simplistic. It's among many other mischaracterisations of the law, I find that the most curious.